First, yes, Judge, I think that's a good start, just to see if he's in the program. And then-
Probable cause conference, August 28th, 2025. 9 a.m. bond condition.
That's 28, Judge?
Yes.
Okay, thank you so much.
Court calls the case People versus Kevin Burden.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burden, Kevin Burden. Sir. And Mr. Kevin Burden is here, Your Honor, and we are just asking for one more adjournment. This case is before Ms. Burton Harris, who asked that we adjourn so we can discuss this a little bit further.
Oh. It is name dropping. Probable cause conference, September 4th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
I saw what he did. He thought I won't get the adjournment on my own, but let me drop this. Court calls the case People versus Melvin Morrow.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Morrow, who's approaching. Mr. Morrow, can you state your name for the court?
Melvin Morrow.
Your Honor, I would ask to address bond. I do have a green sheet as to the PCC, but I would ask to address bond.
Go ahead.
Last time Mr. Morrow was in front of Your Honor for a PCC, I asked to address bond, and one of the court's concerns was his circuit court case that was pending. We went to circuit court last Friday. He was arraigned. He got a personal bond with a GPS tether in that case. So now my understanding is this is the only case that is holding him. So I am requesting the same bond in this matter, a personal bond with a tether. He does have someplace he could stay. He was evicted recently, but he's working with his case manager to see basically where he'll be able to find permanent housing, but he does have family, friends. His girlfriend is here to support him in the courtroom. So he has a lot of support and a place that he could stay while he's figuring out his long-term housing.
Defendant pleads for second chance, promising to stay clean. Viewers, do you believe her, or is this another chapter in the cycle of excuses judges hear daily?
Response.
Your Honor, I believe that Mr. Morrow may already actually have a GPS tracking to the order in the file. If not, I'm certainly be requesting that if he is released. I'm very concerned that given here and absconding that we may lose him again at this time, but I understand that he does in fact need treatment and that the court is likely going to allow it. So I'm just requesting if there is not already an order on the file that when we include. Now, I think Ms. Yagi represented the last time she addressed bond that he would be in fact willing to do that. So that's the people's request.
Probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond in this case will be set in the amount of a $25,000 personal recognizance bond. Defendant is to be fitted with a GPS tether prior to release.
Thank you, Your Honor.
Location. Thank you, sir. Case People versus Tiffany Cash.
Assistant Public Defender Elected Services on behalf of Cash.
You have my name.
Director Tiffany Cash.
They don't want part of this portion. Go ahead.
Your Honor, we'd respectfully request an adjournment. We're still waiting on the prosecutor's office to receive some photos that they've requested from the police department.
How much time are they going to need to?
Your Honor, I did already request them. I just didn't receive them, so I need to follow up. So not more than 2 weeks.
Not more than 2 weeks? You are optimistic. That's what I like.
Well, I mean, I already asked for them, and enough time has passed that they should have sent them to me. So I feel like
You just have faith that everybody's going to act right, don't you? September 4th, 2025.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus, is it Eldonson Orizo Martinez?
On behalf of the people, Your Honor.
Assistant Public Defender Sandra White on behalf of Eddie Nilsson Osorio Martinez.
Name, sir?
Eddie Nelson Osorio Martinez, sir.
What are we doing?
Your Honor, can we approach as to the status of this case?
Case shift, hospitalized defendant, adjournment granted. Sometimes delays aren't strategy, they're necessity. But still, courts must question if illness is genuine or another way to dodge justice.
Record should reflect we had a bench conference in this case. I will adjourn probable cause conference in this matter to September 11th, 2025, 9 a.m.
Thank you, Your Honor.
I'll be in.
Which one? Maybe. You have it with that part.
Yeah.
Sorry. Oh. Oh. Court calls the case People versus John Coffey.
Ashley Feltus for the people.
What? Yeah, what up? Leah, take care of that.
I thought you said a different name. I'm sorry, Your Honor. Kerma Dadush on behalf of Mr. Coffey.
Okay. That's the name I said.
It's my fault. It's never
I
your
know.
fault, Your Honor.
All right. Mr. Coffey, can you state your name, please?
John Joseph Coffey Jr.
Thank you.
Your Honor, we are close to resolution in this case. The people are requiring that restitution be made in advance of an offer. I was going to ask if the court would be so kind as to put an order for $400 of bond to be held as restitution on case 25F31118.
They prepare that order. I'll be more than happy to sign it.
Excellent. That would be very helpful, Your Honor. And then I think we're looking for an adjournment so that can get paid.
How much time will it take him to get that?
I mean, he in 2 weeks should be plenty of time. Right, Mr. Coffey?
Yes, I'm gonna try and take care of it tomorrow, but that'll be plenty of time. I'm working full time, so.
September 4th, 2025, 9.
Thank you, Your Honor.
Thank you.
All right, thank you.
Thank you, sir. Court does call the cases of the People versus Samuel Peoples.
Thank you, Richard. People.
And Alex Warren Green on behalf of Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, in file 1326, Mr. Peoples has not yet been referred to the forensic center. I've prepared an order and we are asking the court to order a forensic examination. In that case,
All right, I will order a forensic examination without objection. On that case, what is my next date? Let's see now. Because has he already started the process?
I don't believe he's been interviewed, Your Honor. The competency hearings on those matters are October 30th.
It's just next week.
That was last week. All right, so set of competence here, October 2025, 9 a.m. All right, what are we doing on the other case?
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in the felony case 1326. Which is charged as a felony, Your Honor.
Sergeant.
Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category that's listed.
Yeah, this is wrong. Okay. All right.
So we would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just gonna remain in custody?
Your Honor, he's working with a social worker. We are asking, or between now and October 30th, we are hoping to file a written motion. I think something substantive that gives the court a better idea.
What's the objection in releasing? I mean, the thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. Or I'm saying, yeah, worse, he cut the tether. I'm not. But he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I had all that anxiety.
Response?
Your Honor, obviously we had an extended conversation about this at bench, at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm concerned that, given that we have this incident, I don't know how sufficient that's gonna be, but I'm fine with him returning to home confinement the previous term.
Defense tries bond reduction for coach accused of exploiting students. Prosecutor fires back. Multiple victims, flight risk, $100K bond. Stakes skyrocket, not just about freedom, but community safety.
Mr. Peoples, if I let you go back home, you're gonna cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before you just did it?
I had a moment of anxiety that led to a freak out. Yes. And I felt like I needed to get it off me because it was claustrophobic and
Got it.
yes.
I hear you. Okay. All right. Here's gonna be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap. Do you know family-wise whether that's available?
Your Honor, we have been in contact with his family. It's certainly something I can ask them.
Pardon?
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
Council approach.
Just say that.
Defense argues relationship turned consensual when victim became an adult. But judge cuts through. The abuse started under his authority as coach. That's the heart of grooming cases.
Yes. Put there on the bond that they're paying $175. Two collections required. Place the strap. And I just need a bond, the blue form, reinstating his previous bond with condition. All right, good. Yes. Okay. All right. Samuel,
Yes, Your Honor.
I give you another shot. You're gonna try to do the right thing?
Yes.
Okay,
Thank you, Your Honor.
all right. I'm gonna do it. I think you can do it,
Me too.
okay?
All right.
Yeah,
Thank you.
so what's gonna have to happen is somebody's gonna have to pay money for the strap that got damaged on your tether.
Understand.
I'm gonna reinstate your previous bond where you were previously at home, right?
Mhm.
And then, they'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right. Thank you, Your Honor.
Okay, don't let me down. You hear me?
Yes. Yes, sir.
Your Honor, may I add one thing? After
Sure.
consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity Ann Arbor without necessarily violating a confinement order. I know it's tricky to do, but they can alternatively contact me and I can talk to the tether agent if that arises.
Response?
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get, seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, which was to immediately notify community corrections office. So that the court would be apprised of what was happening. But the tether conditions, I believe, want to remain the same.
Actually, what happened last time was
Bond reduction denied. Judge even says current bond might be too low. That's a slam of the gavel reminding everyone justice will not be softened for predators.
Mr. The public defender came up on Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back and to do whatever. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Jade, right now.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do was I was told Mr. And I made it very clear, we'll bring him in here. Because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. The request for a tracking tether change.
Stop talking. You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber. All right.